Your Honour, the next person to speak to their submission is Mr Francis Sullivan from the Truth, Justice and Healing Council. You have to sit where you're told, Mr Sullivan.
I can see that.
Would you introduce yourself, Mr Sullivan?
Yes, Francis Sullivan, Chief Executive of the Truth, Justice and Healing Council.
And what does the Truth, Justice and Healing Council do?
The Truth, Justice and Healing Council was set up by the church leadership, that's all the Catholic bishops and religious leaders, as the coordinating entity for this Royal Commission.
Thank you. I invite you to speak to the submission of the Council.
Thank you, Ms Vaness, and thank you, Commissioners, for the invitation. Providing redress to survivors of child sexual abuse, no matter where or when it occurred, no matter who was responsible, no matter the nature of the abuse, is a crucial social issue we as a nation need to settle during the course of this Royal Commission. Bearing witness to the tragedy of institutional child sexual abuse requires both recognition of the history and practical steps by institutions and governments to take responsibility for their failure to protect children and bring perpetrators to justice. That such abuse has occurred at all, and the extent to which it has occurred in the Catholic Church, are facts of which the whole Church in Australia is ashamed. In taking responsibility for this history, our redress and civil litigation submission is a plank of the reform agenda being undertaken by the Church. Like the Commission's consultation paper, nothing in our submission is set in stone. We, like so many others, are here to be part of the conversation, to do what we can to achieve the end result of a workable, practical scheme that upholds individual dignity and helps rebuild broken lives. Our submission aims to achieve two fundamental objectives. One, that all survivors of child sexual abuse across Australia can receive redress based on the same criteria and conditions determined independently and easily accessible, regardless of the circumstances of the abuse. Two, that the survivors of child sexual abuse who decide to take a claim to court are treated with compassion and dignity, that their claim is not blocked by limitation periods, and that there will always be an entity backed by insurance or assets against which the claim may be brought. If these objectives can be met, then an approach to redress built on fairness, independence and compassion should be able to achieve what many survivors and their advocates have been calling for. It should address the concerns identified during the Commission's process about the Church's redress processes towards healing and the Melbourne response, and deliver redress and ongoing help for survivors regardless of the circumstances of the abuse. And our proposal largely supports what is set out in the Royal Commission's consultation paper. Ours calls for a single national redress scheme led by the Australian Government with the participation of state and territory governments and non-government institutions, direct financial redress capped at around $150,000, financial redress that takes account of the severity of the abuse and the impact of the abuse, additional funding for counselling and psychological care, for those survivors who wish it, a meaningful and genuine apology delivered as a direct personal response from the relevant church leader, an application process for accessing the scheme that is as clear and simple as possible, and claims determined on the balance of probabilities. Regarding civil litigation, we have constantly maintained that a fair, independent and generous redress scheme is a better option for survivors of child sexual abuse than the adversarial litigation process. We also understand, however, that despite the difficulties, some individuals will wish to pursue a claim through the courts. For these individuals, there are two particular impediments that should be addressed: limitation periods and identifying an entity to sue. We agree with the Royal Commission's suggestion of reform to the limitation period and suggest it be extended to 25 years after the claimant turns 18, with a further extension available at the discretion of the courts. Secondly, regarding the significant issue of identifying the proper party against which to bring proceedings, we suggest legislation should be introduced imposing a requirement on all unincorporated associations which appoint or supervise people working with children to establish an incorporated entity able to be sued on behalf of the institution. It would be an entity against whom any victim of alleged abuse who wished to sue could proceed. In addition to these changes, the Council supports the Royal Commission's proposal for the introduction of a statutory duty to make institutions liable for child sexual abuse, unless the institution can prove it took reasonable precautions to prevent the abuse. We need laws in our country which will hold all institutions, large or small, accountable for the protection and safety of children. Thank you.
Thank you.
Mr. Sullivan, there's a number of issues that do arise. We appreciate that the Council is suggesting that a national scheme, sponsored, if you like, by the Commonwealth Government, is the solution that should be adopted. What's the Council's position if the Commonwealth Government does not take up that challenge?
A number of things. It's surprising, to say the least, that the Commonwealth Government initiated the call of the Royal Commission, and yet the Commonwealth Government so quickly has discounted itself from one of the most fundamental issues we have to address. You would think that any government that was setting up a Royal Commission of this nature would know that a possible redress scheme would be one option. So I think that conversation needs to continue, because as we see it, you've had a response at a level within the Commonwealth bureaucracy. It'd be interesting to know what the current government of the Commonwealth thinks. Secondly, this is a social issue for Australia. We've heard, as you've heard, that child sexual abuse is not limited to institutional care, although this is the terms of reference. We're talking about something that, as a country, we've at least trying to address at one level, which requires, therefore, governments as our representatives to address this issue and to consider ways in which equity and equal opportunity to redress for every person who's been abused in an institution is effected correctly. At the moment, regardless of its faults, at least since 1997 in the Catholic Church, there's been a redress scheme. You've already announced in your opening that there are some institutions who have provided no redress. So, unfortunately, it depended on the year you were addressed, your postcode, the institution, the willingness of the governors of that institution. Now, surely that is a social issue that governments must address.
So, again, if the Commonwealth still walks away, what does the Council see as the way forward?
Well, we've said quite regularly, it's our policy position that the days of the Church in doing its own investigation of itself are over. We need an independent process, and if it can't be established within the initiative and motivation of governments, we have to get creative about that.
And where do you think the creativity will lead?
To an independent process.
Exclusively to provided to meet the needs of survivors of abuse in Catholic institutions, or do you see a cooperative landscape in which the institutions come together?
Well, you know, as is our spirit in this process, We are not in a position to hector anybody about a set of results. However, firstly, we would want a scheme which was independently administered so that redress can be independently determined and the church components pay for it. Secondly, if that redress scheme can be available for others, we'd be open to the conversation, but very mindful of the fact that other organisations may not want to align with the Catholic Church, given our history.
You said in your oral presentation that you saw the standard of proof for a redress scheme as being framed in terms of the balance of probabilities.
Yes.
Now, many redress schemes in different areas, not just in sexual abuse, and in different parts of the world, have adopted a lesser standard than the balance of probabilities. Why do you think the balance of probabilities is the appropriate standard?
Well, we've thought long and hard about it, and these are the issues that were coming up in our discussion. Firstly, we were advised that, generally speaking, where you do use something like the balance of plausibility, the payment levels in that scheme are relatively low. It's encouraging to see the thinking of the Commission that at least the average payment in this scheme can be as high as $80,000. That's not relatively low, given particularly what you've heard from government officials about what their victims of crime schemes deliver. Secondly, you heard from Mr Gleeson yesterday about the notion that a balance of probabilities is actually a standard of proof where institutions are saying to the individual, we believe you, we believe that what happened, happened, as opposed to saying, we think that what happened may have happened. And that is we've been advised that that's a very important point in regard to the area of sex abuse we're talking about. And thirdly, since 1997, the two, if you like, redress schemes that have been run within the church have been based on balance of probabilities, and, you know, in a vast majority of cases, the victims' stories have been believed.
We learned yesterday that the Melbourne response, and we learnt this indeed when we sat in Melbourne, really seeks to achieve two outcomes. One for the survivor, and the other has a disciplinary component for the church official. I take it that the council doesn't see the latter as being appropriate as a function of a redress scheme?
No, church officials being disciplined is a matter for the internal workings of the church, and you've heard plenty about that in the public hearings. But it does take us to an important point in our submission around the naming of perpetrators. Given the history of the Catholic Church, whatever redress scheme we participate in, it's very important that individuals that have been found against with regard to abuse, the church is aware of who they are.
Well, that leads me to the question I was going to ask you. You would have heard me yesterday say that there are occasions, at least to which I'm aware, where people who very clearly were abused cannot actually identify who it was that abused them. Would that be an impediment, do you see, or does the council see, to achieving redress? No.
Our experience again, and I have to say that we've done a lot of talking to the people who have run the redress schemes over many years, and even when you heard the response when you asked it yesterday, it's not an impediment. It doesn't require direct identification of the individual. As you mentioned in your example, you know, in a boarding school, some children will be able to say this type of thing happened in the evening. We used to see somebody come in. They can't be explicit. That's usually not an issue to knock off their capacity later on for redress.
Yeah. My final issue is the question of the limitation period. As you know, there are a host of options.
Yes.
And indeed the Victorian government are moving towards there being no period at all.
Yes.
Why is the council saying 25 years rather than any other option, if you like?
It hasn't been a simple issue to settle on, and that's partly what I'm saying, that nothing's set in stone here. We've looked at it this way, and it's important. Insurers do like limitation periods, and we were looking at this as a public policy issue rather than a church issue. We're trying to address what would be a public policy structure, and we thought the engagement of insurers in this whole exercise needs to be certain. They would require limitation unless things change, and then if they change, their reinsurers may readjust and so on. So that's one area of advice we received. Secondly, our position is not that there will be strict limitation. In a sense, we're saying there's no limitation. We're simply identifying a marker, and from there it's over to the court to either accept the argument of the defendant that something is that there's a case strong enough to ask for limitation. Generally speaking, when we're pretty well where the mind appeared to be of the consultation paper, that at least a limitation period exercises people to begin to engage with litigation if you want to.
As I understand it, you're suggesting that the foundation for any extension beyond the 25 years, and by the way, it's 25 years after majority, would cast a burden upon the defendant rather than the plaintiff.
Exactly.
The defendant would have to discharge an onus of establishing that they would actually be prejudiced.
Correct, and they have to choose to do that in the first place.
Yeah, very well. Yes.
Sullivan, just one question. Could I understand that your submission in relation to funder of last resort is not to support a position where non-government institutions generally would contribute to the funding of defunct or non-existent organisations? I was wondering if you could just articulate your position in relation to the issue of last resort. Yes,
and the Commission would be aware that we've put in a previous submission on this where we have suggested the best way to, well, an innovative way of dealing with this would be that all institutions who participate in the redress scheme, government, non-government, church, private, are insured, and that there is a levy on that insurance, and the levy becomes a funding pool for being the fund of last resort.
Thank you.
Mr. Sullivan, in your submission at paragraph 24, you say that the redress scheme should be compliant with the mandatory reporting requirements, and this may require redress processes to be put on hold pending the outcome of any police investigations. How do you see the relationship between police investigations and redress working?
Well, it's only just been we're really picking up the experience of what's happened since 1997 with towards healing and other matters, that when either individuals in the process choose to go down another pathway, like an alternative dispute resolution pathway, the redress process stops. So in the case of where individuals go to the police, or where there's an obligation on the part of officials of that institution to go to the police, we would suggest that the redress scheme stops until that process has had its course. At the end of the day, with child sex abuse, your first port of call should be the police.
There's been an issue, as you're aware, in the church procedures as to the role of the person put up by the church in encouraging or otherwise speaking to an applicant or claimant about their rights in relation to the police. And in some cases it's been seen by some claimants that they have been put off going to the police by what's been said in order to get some compensation. And how do you see that being avoided in a redress scheme?
When the number of reviews that were done by Professor Parkinson of Towards Healing, he made it explicitly clear that reporting to the police should be communicated directly to a person coming forward to the church with a claim. In the Towards Healing documentation by about 2010 maybe, that's explicitly put in there. You know, it's clearly not enough to encourage individuals to advise that police need to be informed. You have to be explicit in the policy and you have to make sure that that's followed. To that end, we've just begun a process in the Catholic Church of putting in place a new supervising structure around standards for child protection and the protection of vulnerable people. And that structure will have a series of standards, and obviously what we're talking about now would be a standard. And those standards would be independently audited and reported on. You've got to keep moving the culture of a place like a church or any organisation into the next best practice in this area. And I think we openly recognise that the work in progress at times simply just wasn't good enough.
So is it the case that the administrator of a scheme would require the consent of the victim or complainant to report the matter to the police?
I don't know. This is partly, I suppose, the design issues that we need to discuss. Smarter people than me can work that one out, but I think raising the issue is more important for us at this point.
Thank you. Thank you.
Thank you, Mr. Sullivan, and again thank you and the Council for its contributions to our work.
Thank you very much.
We'll take the morning adjournment.
We will, Your Honour. Just before that, if I can indicate that the program changes a bit after the morning adjournment. We have a panel of 4 who are speaking about the issue of counselling.
And that will be ready for 12 o'clock.
Yes, 12 o'clock, and that will take until lunchtime.
Very well.
Adjourn.
All stand.